Yes, good evening to the students of the SLW616. Karibu sana, welcome to my class of the Advanced Law and Economics. Yes, I allowed the Chuma that let in and you could see my screen. Please read what I posted on the screen. Read loudly. What I posted on the screen, could you read it? You can use your microphone like this. Otherwise, I will get the sound. Okay, no matter. You use your earphone. Meanwhile, I read it. Welcome to the students of the SLW616 Contract Economic Law, that issues are concerns and economics, and hosted by the Professor Dr. Mohammed Saheb Hussain. Now, without wasting the time, let me go to our class exactly that what we are going to deal today. Yes, the 1.2, it is there, law and economics issues in contracting. So we are studying today. In the earlier class, introductory part we studied, that is the economics and the contract, how it together will go. And now we'll see some of the issues are concerned, economics issues in contracting and how it will be connected with the law. That we'll check it here. And when you see the normative issues, what is meant by normative issues? Much normative discussion related to the contract law revolves around the issue of the freedom of contract. So, freedom of contract, yes, parties having the right to choose the freedom of contract, but it is not absolute one. There would be certain restrictions also there. We cannot choose the contract whatever you like it. For instance, can you make a contract to sabotage the bank? Petrolina, can you make a contract to sabotage the bank? Answer, no. We cannot have a contract in that way because there is an illegal activity. To what extent will unregulated private contracting lead to desirable social consequences? So you have to see the social consequences also when you are making the contract with the other party. Whether the contract is a legal contract, whether the contract is a illegal contract, how it can be done. So that is a very important factor. So we discussed this issue. It is a relationship standard issues in welfare economics. Whenever you make it a contract, we will see in the angle of a economic value and social value, and whether it is legal or illegal also we should consider it. At the outset, however, it is worth observing that the dominant normative consideration here, even more so than in other field of law and economics, is a transactional efficiency. A normal method of a contract to see whether it is to be continued or executed, and how it is having the impact on the society, and what would the economic factor would be there, economic efficiency would be there in that contract. So all these things will be considered when you are making the contract with the other party. Those are called normative issues or normative points or values, we can say also. In part, this dominance follows the implicit assumption shared with the most commentators that externalities and analogous market failure are less significant phenomenon in this field of law than they are in, say, tort law. So when you come to the obligations are concerned, it includes the tort law also, because obligation goes with the contract, obligation goes with the tort. Both the things would be there. And hence here it is given that the significance phenomena in this field of the law, then they are in the, say, a tort law. The same tort law, we can see the economic value of a contract. In the same way, in the contract also we will see the economic value of a contract. Because if the contract doesn't produce the economic efficiency, then there is no meaning of making a contract with the parties. So that is actually the essence of it. When you see further, in part, this dominance follows the explicit assumptions shared with the most commentators that the externalities and analogous market failure are the less significant phenomena in the field of law than they are in, say, tort law. So now let us make a point here. Yes, which I highlighted. Anyone can unmute and read by using your earphone. Here I have highlighted. Yes, anyone can unmute and read, which I highlighted there. Read. Is it visible? Which I highlighted there. Why don't you read? Yes, Kitenge, do you have? And are rational in the standard economic senses. That is which I highlighted. It is thus easier to justify applying the efficiency norm to such voluntary arrangements than the typical tort case involving the person drawn together involuntarily outside the market institution. Now I will explain why I read it. So what I read it, yes, it is visible to you. Yeah. Any entity are motivated primarily by the economic gains as opposed to the non-pecuniary considerations. Pecuniary consideration means monetary consideration. Non-pecuniary consideration means no monetary compensation there. So that is the wording. So non-pecuniary, what the wording they say, non-pecuniary consideration. Enter into legal obligations deliberately and at arm's length and are rational in the standard economic sense. Whenever you are making a contract with anybody, you see that what is the economic factor would be there. Number one, if it is non-economic factor is there, how far it is plays the important role in the contract. Based on that thing, we have to make the contract. If any breach of contract comes over there, that will be equally be compensated in the terms of the economic efficiency. That means a person who made such a breach should not be suffered and he should be bring back to the same position as if such a thing did not happen to him. That is called restoration back, redressing, we can say, in tort. So that is actually the thing which is economic sense. It is thus easier to justify applying the efficiency norm such a voluntary arrangement than to that typical tort case involving the person drawn together involuntarily and outside the market of institutions. In certain places, no, a negligence comes into the picture. At that instance, the negligence caused the things to be suffer. At the time, they will calculate how much the damage is happened over there. So this damage should be compensated when they are calculating the damages. So here again, if you go the positive issues are concerned, is it visible? Positive issues 1.2.2. Can you read? Yes.
Positive issues. While the mostly work on the economics of contract law has sought, at least in part, normative conclusions, there is a segment of literature devoted to predicting and explaining how different contract rules affect private transactions.
Enough. Because I am getting the resound here. Because I did not use this one. Anyway, you mute it. Mute. Yes. Well, most work on the economics of contract, law has sought, at least in part, normative conclusions. What is the normative conclusions? What is the positive issues? There is a segment of the literature devoted to the predicting and explaining how different contractual rules affect the private transactions. When you want to make a contract, why do you make a contract with the people? Anyone? What is the reason? Why do you want to make the contract with the people? Sorry, Kubwa.
We get into contract. So the assurance that we at least the performance of our arrangement and the way to contract can be taken and performed in that way that we agreed in the contract. In case of default with one of the party, it's one of the way that we can use such contract if we institute against the defaulting party.
In simple words, contract we can make with the other party for our comfort. Number one. Number two, to save the money and time. Number two. And the thing should be done. Number three. Number four, where we give the contract, at least we can get some benefit. These are the aims generally. In these aims, if any one of the aim is failed, you are the sufferer. Means economic efficiency will not be there. A thing which will be completed within 3 days, if it is completed in the 6 days, the 3 days extra amount should be paid. Is it not the loss to the person? Answer is yes. It is a loss to the person. So, for example, a variety of the authors, they have given the many authors' names, we need not worry about them, have investigated that connection between the use and duration of the contractual agreements and the extent of the relationship specific investment. It depends upon the contractual relations plus time factor. Time factor is also important factor. Because I need it now, this much bags of cement for construction my house. But if we did not supply it, even though there is a contract, at that instance, I would suffer a lot. I would buy from the other people with a higher rate. So that would be compensated from you if you are the defaulted. So here, economic efficiency will be counted. How much that you incurred loss when he did not supply in time, and how much that you paid extra amount to get the same amount from the other people. So that amount will be realized from the person who made such a default. So it is a positive issue of approach. This is. And next is, some other authors have sought to explain the common use of indefinite or open terms or otherwise clearly negotiated agreements, and still others have sought to explain the particular risk sharing or option terms. Risk sharing is definitely would be there. Who will share the risk? Who will share the risk? Anyone? In risk sharing, who will share the risk? But he cannot have that much amount to spare. Risk sharing, any party who is making contract, they will see that any unpredictable thing going to happen, and they take the insurance. That is risk sharing to the insurance. Insurance company will come to their rescue to see that the loss will be borne by if any unpredictable thing happens. Otherwise, the person who is the owner, he will be on the road only with the 2 or 3 pieces of clothes. That much incurred loss would be there. And hence, risk sharing in each and every activity, they keep it out in their life. For instance, if you have the 2 motorbike, risk sharing is there, you will insure the motorbike. Because if any accident happens, the insurance company come to your rescue. So, when you are dealing the contract, yes, you have to see that risk bearing issue we should have to give to the insurance company. So whenever the contract is made from supply of the goods from one country to another country, by the ship, by the vessel, we cannot predict whether vessel will reach to the destination. If any turbulent waves should be there in the sea or the ocean, or any tornado or any other thing happened over there, the ship may sink. Then everything will be collapsed. And that is the reason each and every person, including the ship owner, he'll make the insurance. But the premium is high, but doesn't matter. But security is there. So that is a very important factor. So it is a positive approach to make the contract with the people. So that is one of the method. So while a full survey of this literature is beyond the scope of this chapter, the reader should be aware that many of the issues discussed in the later section have been discussed empirically. Empirically means by practical method. So now let us see the 1.2.3 is concerned economic versus non-economic theories of contract law. How economic versus non-economic theory of contract law will work out. In a positive approach, we will also see that how much the risk would be there and who is going to bear the risk. In the economic versus non-economic theories of contract, they say majority of the contract scholarship is the legal academy has reflected a methodology based on the economic analysis, and most legal scholars in the field have some conversant with economic concepts such as the efficiency, moral hazards, adverse selection, and the like. Now the question comes over there. If any contract would be made, how far the external factor will play an important role also be considered. And with that, we have to make the contract with the people. So nonetheless, a considerable amount discussion in legal circle continues to reflect the alternative conceptual framework. And economists engaged in the interdisciplinary work should have aware of these competing framework of their underlying assumptions. The three major competing perspectives of worth brief discussion here we denote. These are the corrective justice, liberal autonomy, and social constructive perspectives. So, any economist or any person who makes a contract, he will take all measures of all the factors involved to see that whether the contract should be fulfilled or not. So they have come to a certain economic activity, three aspects they made it clear. Number one, what they said is, no, here we denote that this is the corrective justice. Number one, liberal autonomy. Number two, and social constructive perspective. Number three. So these are three aspects of it from where we can get to the economic efficiency. Now let us see what is the corrective justice. Corrective justice is a corrective justice. The most long-standing of these perspective has intellectual roots that trace back to the classical writers such as Aristotle. The classical writer Aristotle, they say perspective quotes that the judicial institutions are only justified in acting to redress the unjust or wrongful situations. The judicial agency, they will see merely what is going to be incur the loss. That they only see it. But when they want to see the perspective means how far that a good life that you are going to lead it later, number one. How far that you are enjoy the things. Number two, if any accident happen, I am speaking. If any accident happen, if you become a lame or lost your leg, at that instance, merely giving the money is not the thing. We have to see the perspective of a life of a person. Suppose if he is not married, then who will marry a lamed person? No one marry unless until he is having a good valet, a good businessman, and having a good quality of at least looking good. So perspective also will be counted over there, not merely giving the money compensation. Sister, you come this side a bit so that I could see him. Come this side. Yeah. So that is the point here. What I want to say is The perspective holds the judicial institutions are only justified in acting to redress the unjust or a wrongful situation. But the judiciary, what they say, they see only how much the compensation should be given. But the judiciary also should see that what is the fair chances of him to get married when he became a lame. That also will count it. Suppose if it is a good soccer player, a football player, then he lose the chance to for the World Cup. So that also be counted. Is the perspective of the life. So judiciary should have to take the account of all those aspects also, and then they will calculate it. That is the economic way of calculating and giving the justice to the party. Because whatever the amount you give it, you cannot get back your leg. Am I true? So at least it is a ufuta jasho. Najua? Ufuta jasho. A solace. It is merely a solace, but not exactly the compensation. It is merely a solace to give something. So that is the point which they want to make it out. And the corrective justice approach seeks the restoration of some past and proper state of affairs and thus can stand and art with an economic approach to law. The corrective justice means that justice not merely giving the kidogo amount for the compensation, but prospective of his life. That also be counted over there. That is the corrective justice in awarding the damages. And that should be followed. I don't know whether you study in the law of tort. Yes, they can count it. What is his prospective of marriage? And what he is going to get it when he is going to die after so and so age? And what about his life, children, and activity and promotion? So they seek all these things, then only you can say it is a corrective justice approach. And seeks the restoration of some past or proper state of affairs that can stand and arts with the economic approach to law. So which tends to regard past gains, see here that economic approach to law, number one, which tends to regard past gains and losses as sunk and to emphasize incentive for future behavior. Future. Suppose if you met with an accident, you have a artificial leg. A artificial leg would be there. And if the accident happened at the 45 years age, think that you are going to still live for the 6 years, 60 years. So that means 15 years you are going to live. Let you presume it. So each year you have to buy one leg which will last longer for 5 years. That means you have to buy at least 3 artificial legs to complete the 60 years. Is it not the prospective estimation of the cost of bearing it and calculating it? It is the corrective justice. Number one, they calculate the 3 legs because he is going to die after 60 as an average, but now he is a 45. But one artificial leg work for the 5 years. After 5 years, it will be 2 pa. Taka taka. So 5 into 3, 15. So he has to incur, and each year the cost is increasing. So 5 to 10% value added for the cost. Because now what we get today, we cannot get it next year in the same time. The cost will be increased. So they will calculate the cost also, they will measure it. So that is the corrective justice method. By following the economic analysis, they give the justice. And that is actually the real justice. So they say the corrective justice approach seeks the restoration of some past and proper state of affairs and thus can stand and arts with the economic approach to law, which tends to regard past gains and losses sunk and to emphasize the incentives for the future behavior. It is less clear, however, that the corrective justice approach has any implication of all ex ante analysis of the legal problem, and many legal writers in these traditions, they will make it out. How far that you will make the corrective justice when you are giving the judgment? When you are giving the judgment, it is not the judge will make it out. It is your counsel will make it out. It is your council who will give these are the points, these are the points, these are the points. That means all the slides they will make it out. When all the slides they will make it out, then the judge, you have to satisfy the judge. Like I told you, 45 years he met with an accident and he became a lame. When he became a lame, he could not play the World Cup and he needs the artificial leg and he could not get the beautiful wife and he could not get a good job also, even though he is having a temporary job also, but he cannot do such a job which needs standing. He can do the job of sedentary by sitting only. So such suitable job would be there, but that job doesn't have the much money salary, and all these slots we have to make it out. When all these slots you make it out, yes, then we can convince the judge. That is a corrective justice to make the future losses. To make the future losses. So that is the emphasis will be given over here when you are making the cases to be dealt, and amount will be damaged. Amount will be added for the as a damages. So that is the actually the thing corrective justice is concerned. Now liberal autonomy, second point. First is the corrective justice, second is the liberal autonomy. In the liberal or autonomy based perspective, that is emphasize that individuals as opposed to the collective interest, and they say from this point of view, individuals' rights should take priority over more general concern of society. Individual rights should be taken a priority over more general concern of a society. So individual will be given a priority over there, because it is the individual who suffered, not the society suffered. So individual suffered, the priority should be given to the individual to see that he should be comfortable in the society. So here say individual rights should be taken the priority over the more general concern of the society. Such a perspective is plainly more constant with the economic approach, that is corrective justice perspective. So when you want to make it the second point, liberal autonomy is concerned, the liberal autonomy is solely based on the corrective justice, because these are all the variables. So each variable depend upon some other variable. Then only we can give a correct point of view. So here they say such a perspective is plainly more constant with the economic approach. There is the corrective justice perspective is the right approach. And the standard economic measures for welfare are based on aggregates of individual utility, and under conventional assumption of the welfare economics, liberal freedom tend to lead to the describe the economic outcome. So here what they want to say is standard economic measures of welfare are based. What is the standard economic measure of based on aggregate individual utility? For instance, if you take the cost of living of a person for his livelihood, what is the minimum wage to given in Tanzania for a man and a woman for casual labor? Did you understand the question first? Casual labor, do you know what is casual labor? A casual labor in the morning, they they congregate at one place, assembled at one place. Those people they want some work, they come to that place and pick them, depending upon the nature of the work. Either women also there, men also there. And generally men does the mason work, construction and digging work, and women will do the spade work, taking the sand and throwing in some other places. Do they pay equally in minimum wages? Okay, roughly, how much they pay? Per day, I'm speaking. For men or for women? What about a woman? I will tell you the India. In India, if suppose 600 rupees will be given to the men and 4 to 5 depending upon nature. Sometimes 450, sometimes 4, 200 difference will be there. Because men is having more skilled work and the woman is having less skilled work. And man having the more hard work because he stand on the gallows and he has to construct it. And this woman will be down and she just mix the sand and other thing and gives to him. So 400 is for women and 600 for men is a casual labor. But how do you measure it? So they say it is the individual utility of a person to have a good life in the society. Of course, the society good life means even that much amount is less amount, that is. But at least in the society one can survive. So they said here, in a society they can survive here. Assumption of welfare economies, liberal freedom tend to lead to the desirable economic outcomes. So economic approaches, however, whenever the market failure or transaction cost prevent the completion of the efficient exchange. So in any matter, an individual, how much will be needed to lead a good life, that much amount of will be paid to him, and that is the way we can calculate it, the liberal way. The liberal way of to calculating it. For instance, you take the mental work. The mental work, a woman also does the same work like a man. So the mental work, generally there is no disparity. The same amount pay would be given to the woman, the same amount will be given to the man. Even though both are scientists or both are doctors, no matter. Because equal work could be there of the mental. So that they will calculate it and they will pay it. There will be a tension between the liberal and economic approaches. However, whenever the market failure or transaction costs prevent the completion of the efficient exchanges. See, when you say liberal approach and economic approach means stringent approach. Liberal approach means free and frank approach. So, when you want to use the liberal approach and economic approach, depending upon the situation is concerned, and that is the liberty would be given to a judge to decide the case and give the compensation. And it is the client also should think in that way. Can you get the same compensation for a man who is a rickshaw puller and a man who is a medical doctor? Answer is, a rickshaw puller will get the less amount, but a medical doctor will get the more amount. Why? Because of his status in the society and his earning in the society, his need in the society, and his value of life in the society. So all these things will be taken into consideration, and the liberal approach will be given more, and the stringent approach will be given to the rickshaw puller. So that is the reason there is a conflict between the liberal approach and the economic approach. In a contractual setting, for instance, liberal theorists might argue the obligation to which the parties have not knowingly consented may not be imposed to them, even those obligations would be both efficient and distributionally equitable. Conversely, libertarians might argue that the law should protect even anti-competitive agreements such as the price fixing, and still 5 minutes are left. On the basis that the conduct is voluntary and the consumers have no interest right to trade with the producers on any particular terms. Now the question comes over here. What they say, if the liberal approach would be there, sometimes it's a very difficult task. A liberal approach would be there. From Monza to Darussalam, 10,000 bus fare. Can you make it out? All the people will kill you if you make it out. Feasibility is there. Liberal approach, you cannot make it in the fair competition there. Okay, you can give them food free, chakula bure, with a not ingombe, mbuzi. But you cannot make it a market. A market is having a rate. And that rate one should not be come down. And then only the economic efficiency would be there. And you cannot make it whatever you want in the society. And competitive, anti-competitive agreements. In the agreement in the field, there is a standard level of cost is there. Okay, not less than 40,000 or 50,000, depending upon the luxury bus, whether it's a luxury one or self-contained one or QOZ or AC bus. So depending on Volvo, so depending upon it, okay, it will vary. But to want to beat other people, one cannot reduce their price. In the competitive market, you cannot be that much liberal. You should be liberal, but to the extent of a certain standard to get it. So liberalism might be argued that the law should protect the anti-competitive agreements. Anti-competitive agreements such as price fixing, on the basis that the conduct is voluntary, that consumers have no inherent right to trade with the producer on any particular terms. So, amna punguza, amna ongeza. Najua. Rate is fixed. When you go into the mall, can you make the punguza? Like a mama auntie liye? Auna machinga? There is no such a punguza or ongeza. The price is fixed. Either you take or go. But in the buses also is a punguza and ongeza there. But only those buses are there, mini buses. There is some punguza ongeza, they can make it out. But the luxury buses, self-contained buses, no punguza ongeza. Rate is rate, fixed. You take it and go away. No, I will sit in the Kugoda. Can he reduce the price? Answer is no. Even though you are allowed to sit in the Kugoda because you want to go and it is your necessity. And the same charge he will make you, even though you are Kugoda on the stool. Because your necessity, you sat it, otherwise you say get down. So that is another point where we want to make it out. Then the next class we will see, because at any time it will stop, because it is only the 55 minutes time. So social constructivism we will see in the next class. And meanwhile, if you want to ask any question, you can ask it, because my limitation is 1 hour or 50 minutes. In 50 minutes, you can concentrate, you can listen, and it will not be a boredom to you and to me also. Otherwise, 3 hours at a stretch. You know, Najwa, dripu. Dripu, Najwa. What will happen if a dripu to increase? What will happen? That fellow will die. Pneumonia. He will die. If your dripu is given you, which is either any dripu, doesn't matter, any dripu. Because the drop should fall, your body should sustain and take it out. If you increase it now, that fellow becomes cold and he will get the pneumonia, and automatically after some time, if no one could see, he will die on the spot. So my point of saying is pole drip. Amna? Kufa. So I don't want to make kufa. That's why I told you, 3 times I will teach. 50 minutes, 55 minutes, whatever you get it, at least get directly to your mind. So now this is the physical class. I can give you a 50 minutes. And today again I will take the 9-10 class to you, but that is online class. And again we have the class that is also
Mungu ibariki Afrika, wabariki viongozi wake. na amani. Hizi ni ngao zetu Afrika na watu wake. Ibariki Afrika, ibariki Afrika, tubariki watoto wa Afrika. Mungu ibariki Tanzania, dumisha uhuru na umoja wake kwa waume na watoto. Mungu ibariki Tanzania na watu wake. Ibariki Tanzania, ibariki Tanzania, tubariki watoto wa Tanzania.
Asante sana na sikiliza mimi darasa online. Mungu akubariki na kukulinda.